Yes, my students, you are welcome. Or is it me that is should be welcome? We now have to go to another important part of the lecture: enforcement. What is enforcement? Enforcement has been defined as the application of a set of legal tools, both formal and informal, designed to impose legal sanctions or penalties to ensure that a defined set of requirements is complied with. Compliance is therefore the ultimate goal of any enforcement program. Enforcement, according to Macmillan English Dictionary New Edition, is the process of making sure that something happens, especially that people obey a law or rule. We have other definitions. We can also say enforcement is a set of actions that government or others take to achieve compliance within the regulated community and to correct and halt situations that endanger the environment or public health. It is also the act of compelling compliance or the act of compelling observance or compliance with a law, rule, or obligation. It is an application of law or regulation or carrying out of an executive or judicial order. And you know, we have these are public health laws, we have environmental laws, we have different laws. If people violate these laws and there is no way to enforce it, then there is a problem. People continue to break the laws, to violate the laws, but there must be a means of compliance. Compliance will ensure that ultimately whatever the law make, people comply with it. If they violate it, there is a way of getting them to obey. This is all what enforcement is about. And we have enforcement agents in environmental health. Ministry of Justice, 1. 2. Ministry of Environment. 3. Ministry of Health. 4. The courts. 5. Environmental Health Officers Registration Council of Nigeria, EHORECON. It has since changed now. It is now referred to, instead of EHORECON, it is ECON, that is Environmental Health Council of Nigeria, ECON. 6. National Agency for Food and Drug Administration Control, NAFDA. 7. National Environmental Standards and Regulations Enforcement Agency, NESTRA. 8. National Drug Law Enforcement Agency, NDLA. 9. The police. These are the 9 that I've just put here in your note, but they are more than that. So what is the role of the Ministry of Justice? This is a governmental department headed by the Attorney General, who is a chief law officer of the state or chief law officer of the federation, when it is the Attorney General of the federation. You see, like I said, we have 3 tiers of government: the federal government, the state government, and we have an Attorney General for the federal government. We have an Attorney General for the state government. The Attorney General for the federal government also doubles as the Minister of Justice. For that of the state, his position is also the Commissioner. The Attorney General is also the Commissioner of Justice. So, the ministry prepares and enforces the laws. Attorney General and his members of staff, including the Director of Public Prosecutions, DPP, institute and prosecute criminal cases, including environmental health offences, on behalf of the federal and state governments, respectively, in Nigeria. In a criminal case, the state is the prosecutor. So all the cases, whether we have the private prosecutor, we have the we have different types of prosecutor. We have the police, we have the environmental health officers also prosecuting environmental health cases. The custom, we have the custom also prosecuting their own cases. But the power to prosecute the cases the such power is from the Attorney General, because the Attorney General is the chief law officer of the state, if it is the state government, or the federal, if it is the federal government. So it is assumed, in fact, all the prosecution being done by these body other than the officers from the Ministry of Justice are being empowered by the Attorney General. The police officer who is also a state official does so on behalf of the Ministry of Justice in minor cases in the magistrate court. If an offender is found guilty of the offence charged, he is sentenced to a term of imprisonment or a fine, or may be cautioned and discharged. The environmental health officer who prosecutes environmental health cases in court draws his power to do so. I've told you, from the implied permission granted by the Attorney General, who is the head of the Ministry of Justice, and the public health law, which gives the health officer the power of a police officer has for the purpose of prosecution of environmental health offences. So, under the public health law, various public health laws, we have a section which gives the environmental health officer the power to prosecute cases, the power of a police, the power possessed by a police, the power of arrest, the power to detain, the power to prosecute cases. So, but this power has the permission, or the prosecution has the permission granted by the Attorney General, who is the head of the Ministry of Justice, and of course, the chief law officer for either the state or for the federal government, depending on whether it is federal law or the state law. We have Ministry of Environment. Ministry of Environment has the responsibility to administer and enforce environmental laws, guidelines, policies, standards, and regulations in Nigeria. The ministry ensures effective coordination of all environmental matters. It monitors and enforces environmental protection measures. Under the Ministry of Environment, we have some of agencies like NESREA, ECON, and so on. So we have the Ministry of Health. The Ministry of Health is established to develop and implement health policies and programs and undertake other actions to deliver effective, efficient, quality, and affordable health services. It undertakes health promotion, surveillance, prevention, and control of diseases. So one of the departments of the Ministry is the Department of Environmental and Sanitation, which plays a leading role in the prevention and control of preventable diseases. And the other one, the court is a governmental institution charged with administration of justice according to laws. They have judges and magistrates which decide the various cases. When the Ministry of Justice will bring the offenders to the court, and the court, of course, whether it is environmental health, sanitation offenses, or any others, it is the court that will decide the case. So the court has an important role to play. Environmental ECON is a professional regulatory body. It was established in 2002 by the Federal Act number 11, and it has just been amended by the Act of 2022. And in summary, the agency have the following responsibility: to promote the health of the public, to maintain the healthy standard of the public, to monitor and help to enforce environmental protection measures, to cooperate with one another, example, federal and state ministries, local government, statutory bodies, and research agencies on matters and facilities relating to environmental protection, to enforce laws and regulations on the environment, to create environmental awareness, and to engage in partnership in the protection of the environment. We have the NAFDAC. The NAFDAC is the National Agency for Food and Drug Administration control NAFDAC. This is a Nigerian government agency under the Federal Ministry of Health that is responsible for regulating and controlling the manufacture, importation, exportation, sale, and use of food and drugs intended for human consumption and fit for the other purpose. The vision is to safeguard the public health of the nation, and the mission is to safeguard the public health by ensuring that only the right quality of food, drugs, and other regulated products are manufactured, exported, imported, advertised, sold, and used. Then we have the National Environmental Standards and Regulation Enforcement Agency, and I think we have already discussed this. And we have the National Drug Law Enforcement Agency. You can see that we have some youths now. They are taken to drugs. They smoke in their hand, cocaine, and so on. It is the responsibility of the NDLEA, National Drug Law Enforcement Agency, to prevent this. So their functions: adoption of measures to identify, trace, freeze, confiscate, or seize proceeds derived from drug-related offenses of propriety whose value corresponds to such proceeds. Then B, adoption of measures to eradicate illicit cultivation of narcotic plants and to eradicate illicit demand for narcotic drugs. The agency cooperate and collaborate with government bodies within and outside Nigeria to suppress the international activities of illicit traffic in narcotic and psychotic substances. We have the police. All of you know the function of police. They are peace officers. They ensure there is security, there is peace. In order to achieve this function of enforcing the law, prevention of crime, the police have a broad discretion, which includes their powers of arrest and detention, instituting and prosecuting cases in court. The police liaise with the Office of the Attorney General of the Federation and Office of the State Attorney General, as the case may be, in respect of cases that require their attention and cooperation, especially on serious crimes and civil litigations. Now, what do we mean by civil law and criminal law? Criminal law, the body of law defining offense against the community at large, regulating how suspects are investigated, charged, and tried, and establishing punishments for convicted offenders. It is also the branch of law which defines what public wrongs are, considered crimes, and assign punishment for those wrongs. Crimes are acts of commission or omission which are prohibited by a written law, which, if done or not done, are met with prescribed punishments. So, we have in the South criminal code, which consists of offenses and punishments prescribed for the southern part of Nigeria, and for the northern part of Nigeria it is penal code, and they are almost the sections are different, but in most cases they are saying it, but we have some differences between them. What are the for civil law? Civil law is the system of law concerned with private relations between members of a community rather than criminal, military, or religious affairs. In civil law, when you have your insurance, when you have your contract, I want to build a house, please come and help me to build, come and help me, this is the contractor, you're buying and selling, and so on. Some problems may arise, some people may breach, but these are not classified crimes or criminal, but they are just violation of your rights and so on, and so these are classified under civil law. What is the difference between, how do you differentiate civil law from criminal law. Civil law aims to compensate an individual. When you are bring a contract, you are compensated. Corporate body or government that has suffered some legal injury, bad reputation suffered by people due to defamatory words, written or altered by another. You know, if somebody just abuse you, call you the name you that does not belong to you, people may be called ashewo, prostitute, war, and so on. And if that is published, people now see you that you can take that person to court. And the court, if the person is found liable, will pay heavy damages. So this is aspect of civil. This is civil law. But whereas why civil law is for you is for compensation, the criminal law is for punishment, to deter the offender, so that it doesn't, and to deter the offender and any other people that may not want to commit similar offense. So the criminal law will impose punishments such as imprisonment, fines, whipping, forfeiture, even death penalty on an offender. If somebody has committed a murder in Nigerian law, if that person is found guilty, he is also the case maximum capital offense, which is a death penalty. Criminal law is usually is the state versus, when we go to court, when we charge somebody to court, it's either state versus the offender, Ojo Aina, or commissioner of police versus this, like Thomas, commissioner of police versus Thomas Jagun, state versus Thomas Jagun. But when it is civil, it is not so. It is individual. Ojo Aina versus Olu Joseph, and we have some other civil matters like when if you are an association of husband and wife that has gone derailed, what do? You want to separate the association. You want to appropriate the association. You go to court, and but you don't charge. In that case, you say you petition the court, and it is Ojo Abiodun versus Aina Abiodun, and that is also, that comes under civil matter. So, and most people get it wrong when they say they refer Ministry of Justice as the court as part of Ministry of Justice. It is not so. The Ministry of Justice is not for judges, as some people erroneously assume. While the Ministry of Justice is under the executive arm of government, judges are under the judiciary, which is another arm of government. So, summary of the difference. The difference between the civil law and criminal law turns on the difference between two different objects which the law seeks to pursue: redress, payment or compensation for damages or injuries, or punishments. Civil proceedings are taken for the purpose of obtaining compensation for injury and may be distinguished from criminal proceedings whose purpose is to inflict punishment. For civil law, the wrongdoer is not punished. He only suffered much harm as is necessary to make good the wrong he has done. The person who has suffered gets a definite benefit from the law, or at least he avoids a loss. On the other hand, in the case of crimes, the main object of the law is to punish the wrongdoer, to give and others a strong inducement not to commit crimes, to reform him if possible, and perhaps to satisfy the public sense that wrongdoing ought to meet with retribution. A nuisance is anything which, in the unreasonable or unlawful use of one's property disturbs another in the lawful and productive use of his property, endangers the health and safety of others, or violates the standards of decency. Nuisance is a ground for tort action against the offender. But in our public health laws, you all know, if I ask you what is public health law and what is a nuisance, all you need to tell me is any act, omission, place, or thing which is or may be dangerous to life or injurious to health or property. And this appears to be commonly adopted as the definition of what a nuisance is by most health officers. It is also correct, but you must know it that it is anything which is in the unreasonable or unlawful use of one's property disturbs another in the lawful and productive use of his property. So when you act of you create certain thing, a nuisance that disturbs another one, it is a nuisance, and for which you are liable, and you are liable under the law of tort to be punished. Yes. So if you commit any wrong, any nuisance that affects your neighbor, you are taken to court. If you are found liable, then you will be like I told you, civil law is not punished, but you will be asked to pay damages, compensation. And we have different types of nuisance: public nuisance, private nuisance, structural nuisance, non-structural nuisance, statutory nuisance. So you must be able to differentiate between all these. The public nuisance involves an unreasonable interference with a right common to the general public. It is to be noted that the public nuisance can constitute either a crime or may be the subject of a civil action by public officials or private individuals. For a private nuisance, the private nuisance is a nuisance that affects an individual or a definite number of persons in the enjoyment of some private right, which is not common to the general public. It is to also be noted that the origin of private nuisance liability is purely tortious in character, and the tort is developed to protect the use and enjoyment of land against non-trespass interference. Because a nuisance that causes harm to people or damages property, you may be causing a private nuisance and could be sued by individuals or organizations. You may have to attend the court hearing and pay compensation or damages. Structural nuisance are nuisances which occur as a consequence of the tear or deface or omission or commission from houses and buildings and their corresponding structures and premises. Non-structural is any nuisance that is not structural. They arise as a result of the act, default, or activities or commission or omission to carry out activities in the premises by the owner or occupier of premises. Examples include a heap of garbage, overfilled sanitary dustbin. Others include noise and vibration, smoke, fumes, and gases, dust, steam, odors, kept animals, waste deposit, for example, with the risk of vermin, blocked drains, and stagnant water, and so on. Then we have statutory nuisance. These nuisances caused by certain conditions set out in legislation are called statutory nuisances. It is any nuisance that is coded, that is, it is contained in the law. This is what is called statutory nuisance. The statutory nuisance is a nuisance prohibited by the statute. What do we mean by statute? That is written law, something written. So know that statute is written of by the statute. Statute means written. So a statutory nuisance is a nuisance created by the statute of a community, be it federal, state, or local government bylaw. Some examples of environmental health nuisances are, you can see, defective pit latrine, burial or condemned carcass of a deceased animal, contaminated bread in an insanitary bakery meant for sale for human consumption, collapsed water closet, toilet with human feces and still in use by occupants, willful exposure of human waste inside a defective septic tank, rubbles of a collapsed building turned to a dump site, a room converted for indiscriminate defecation liable to spread communicable diseases. If your local government, if your local environmental health officer finds that a statutory nuisance exists or is likely to occur or recur, your local government can serve you with an abatement notice. An abatement notice can require you to stop causing a nuisance or impose restrictions on your operations to prevent any further occurrence, or to carry out works or take other steps to restrict or remove the nuisance. Note that individuals can also bring a statutory nuisance case to court. So what is an abatement notice? Abatement notice is a notice, order, or document required or authorized by the public health laws to be served on the owner or occupier of premises or author of a nuisance to take such corrective measures that are necessary to abate or prevent the occurrence of nuisances in such premises. An abatement notice is a legal document, and if you do not comply with it, you could be prosecuted. Know the contents of abatement notice. The serial number of the notice, title of showing the law, and section of the law under which it is prepared, name of the owner of premises or the occupier, date of preparation, address of the premises, address of the owner, details of the nuisances to be abated, purpose, reason for the abatement, details of work to be carried out, time limit, name and signature of the officer issuing the abatement notice, name and address of witnesses, name and signature of the receiver on the counterfoil. And how do you serve an abatement notice? You can serve on the owner, serve it on the occupier, and you can paste it on the conspicuous place on the premises. What is enforcement procedure? Of course, this is what you have done in the past. Enforcement procedure begins from when you conduct your general inspection, you detect the nuisance, you give oral warning, summary abatement of nuisance, service of abatement notice, verification of abatement notice. And when he fails to comply with this, with your instruction as stated in the abatement notice, you will prepare a charge sheet in copies and filing it in court. Court summons is issued. What is court summons? Court summons is a document issued by the court asking you to come to appear in court at a stated time to defend a case or the allegations leveled against you, or to come to court as a witness, to come and testify in respect of a matter. Hearing, prosecution and defense. The prosecution will state his case. When he closes it, the defense will also state his defense. When he closes it, the court will give judgment. when the judgment of court may contain penalty by way of payment of fines or imprisonment, then the court will give you a nuisance order. What is a nuisance order? A nuisance order may be an abatement order, a prohibition order, or closing order. Then it is the responsibility of the environmental health officer to ensure that there is enforcement of court order, that is enforcement of the judgment. Then this takes us to court documents. We have charge, the charge sheet. A charge is said to mean the statement of offense or offenses with which an accused is charged in a summary trial before a court, while a charge sheet is the document before a court which informs the court and the defendant of the allegations leveled against the accused person and contains the charge against him. The purpose of the charge sheet is to inform the court and the accused of the allegations leveled against the accused by the prosecution. Then what are there is also form of contents of the charge. A typical charge, you know that in any charge, the following must be included in framing the allegation against the accused. Which court? Is it the magistrate court? The form and content of the charge shall include the following, that is, the heading of the magistrate court, the heading of the court, which will include the respective magisterial district in which a criminal proceeding is to be instituted, the charge number, the constitution of the parties. Is it state versus accused, like the commissioner of police versus Thomas Bukola, the main body of the charge, which will extrapolate the statement of the offense and the particulars of the offense in one paragraph. Name of the accused person, date of the alleged offense, of the commission of the offense, place of the commission of the offense, statement of the offense committed, date, the name and signature of the prosecutor on behalf of the state. Then your note. Look at your note. I've given you examples of charges. So study it well. In your examination, you may be asked to prepare a charge. To prepare a charge, you can be given that at so place, a person has committed this and this and this and reduce that to a charge. So you have various examples here how charges can be prepared, whether it is one count, whether it is a one count charge, whether it's a two count charge or three count charge. You have the examples here. So, summons, I just told you that the summons is court order notifying a named party that the case involving it has been filed and it must make an appearance on the stated date to answer the charges or give evidence. You have summons is also has a way it is structured. Look at your note, it's well stated there. And I want to thank you for listening. If you have any question, you have to put this down or in the platform, in our platform. When you have any question in the platform, you ask me and I also reply you. Because or anytime, or you can wait till when I make physical appearance, then you can ask me all these your questions and that. But rather than for you to wait till when I come there physically, you can always write it in the platform, and I will also answer your questions. Thank you. God bless you.